Hi everyone, I hope all of you are doing well. So, as promised, I'm here back with my second video of this series titled as Nuances of Mooting. And in this particular segment, I'll be covering as to how exactly one should make a very good memorial so as to win a Best Memorial Award in any moot court competition. Before I go into the specifics of any memorial, let me just make you guys understand as to how important it is to have a very good memorial if you're participating in any national moot court. Now, most of these moot courts have a tendency of drafting the rules in such a way that your memorial marks will constitute about like 40% of your overall qualifying marks. For example, if you need 100 marks as a total marks scheduled for your qualification, or for say if for example even for one round if it's 100 marks, maybe that the rules provide that I have seen a lot of colleges doing this, that your speaker scores and the memorial scores will be divided in the ratio of 60s to 40. That means whatever you get from 100, so far as the speaker scores are concerned, that will be then given out of 60 marks, and that will be divided in a pro rata basis with respect to your memorial marks constituting another 40 marks. Therefore, please be very careful and never ever neglect having a good memorial with you, because sometimes even if you are a really good speaker, if your team performs really well in the oral rounds, you might just not qualify beyond prelims, or maybe in quarters, beyond quarters, uh, because of your low marks in your memorials. Therefore, please take and consider the memorials equally important as you consider your oral rounds, so far as your moot performances are concerned. So, starting with the key ingredients of a memorial. Now, I'll just go by the ideal memorial, and I have hardly seen the rules of the moot courts deviating from the standard memorial format. Therefore, I'll go by that particular format. So, I'll while also mentioning about each and every format ingredient, I will side by side explain each of them so that we go in a holistic manner and we cover each and every segment of any memorial, because equally important to understand that each and every page of a memorial has the same significance and value. So far as your marks are concerned, there are marks allotted for memorial. They get divided in various ways. There are even some colleges I've seen who divide the marks segment so far as your look of a memorial is concerned. That's unfortunate sometimes, but yes, your clarity, your the way you put your memorial forward, that's also important. Therefore, yes, we'll consider a lot of these aspects. So, starting with, firstly, you need to be very careful about understanding the proper format that is ideally provided in the rules of the particular college which is actually hosting the competition. Therefore, just adhere to the rule book of the competition, and ideally a standard format will first constitute any cover page. That's very normal, that's very standard, but you need to be careful about what all should be put in an ideal cover page. Now, number one is, you need to be thorough with understanding of the provision of law under which you need to approach the court. That is number one, as I have already even discussed in my first session regarding the moot court strategy. You need to be very careful about understanding the provisions of law, and therefore you need to be also adduce as to what court are you approaching. That name of the court should be mentioned right at the top of your cover page, and that the provision of law under which you're approaching the court will be followed just underneath the name of the court. That means if you're approaching the court under Article 32 for a violation of fundamental rights of certain individuals, the cover page will clearly mention that. Right at the top, it should be mentioned as in the Court of Honorable Supreme Court of India, followed by under Article 32 of the Constitution of India 1950, that being your provision under which you are approaching the court. Yes, so therefore, name of the court and the provision under which you are approaching the court leaves a prima facie impression with the mind of the judges who are evaluating a memorial, whether you are actually understanding the nuances of these, provisions, and therefore be very careful while drafting your memorial and choosing the right forum. Secondly, your cover page will also mention the name of the members, as in who are the parties, and that is basically the cost item. You need to be very careful as to who has approached the bench and who should be ideally the respondent given this state of facts. Now, for example, if you are uh, claiming violation of fundamental rights, but you are making someone else as a party respondent instead of the state, that is where you go wrong, because the provision of Article 32 is very clear that only the state can be the respondent in an Article 32 petition. Therefore, you need to be very, very careful, and you need to understand these nitty-gritties of each and every provision, and that is how important your cover page is. Because merely by writing a name of an individual, you might think that, okay, you have done the right thing, but maybe the provision of law does not allow you to do that. Therefore, please ensure that your cover page, your everything you write in a memorial adheres and conforms to the mandate of law. And you therefore need to be very, very thorough with your research in all those aspects also. Last thing you need to mention in the cover page is the name of the party which is filing the present memorandum. That means if the petitioner is filing, you need to mention that the memorial is filed on behalf of the petitioner or is it the respondent. Same goes for whether it's an applicant, whether it's an appellant, whether it's a petitioner, does not matter. The format remains the same, and that's how you need to clearly lay down your cover page, which leaves the first impression with anyone, because that is what someone will see for the first time. Therefore, make sure you commit no mistakes at all in your cover page. That does not obviously mean that you are free to commit mistakes. All I'm saying is be extra careful, be extra diligent so far as your cover page is concerned. Secondly, the second thing that you need to be careful about any memorial is the prayer. Although I'll come to the prayer later, I just wanted to mention that right away, because there is a tendency with the judges where both while your orals are concerned and also during a memorial evaluation, they first go and check the prayer, because writing a proper prayer is very, very important, and prayer ideally gives an understanding whether a candidate or a team has understood the provision of law well, have they understood the facts well, because your prayer, the things you ask as a relief, is very, very important to understand whether you have actually in fact understood the whole proposition, the applicability of facts, the applicability of law, etc., etc. Therefore, yes, prayer is very, very important. As I mentioned about cover page, prayer is also something that leaves a prima facie impression about your preparation for any moot court. So please be very, very careful even while drafting your prayer. I'll come how to draft a prayer, how exactly you should go about mentioning certain reliefs in the prayer later towards the flag end of this session. But I just wanted to highlight at the outset for the reason I just mentioned. So yes, the second aspect regarding any moot court memorial, as in the second ingredient, is a table of index. Now, table of index, as we all know, will just cover each and every element of the moot court memorial alongside proper page numbering. So, for example, if it's covering statement of issues, jurisdiction, facts, summary of arguments, arguments advance, etc., etc., please write the corresponding page number at which it's located in the draft, and also mention the issues, sub issues, everything should be there in the index itself, so that it's page numbered in such a way that if someone wants to directly go to a particular issue or a particular page, they easily get the page number reference right at the second page of the memorial itself. That may run into 2 or 3 pages, don't worry about the page limit, but make sure your index is complete in all manners, because that's very important. Like, there are certain elements, I can tell you from experience so far as my moot court participation and now judging is concerned. We have a tendency of having a good impression about the team if the formatting is nice, if the page number referencing is good, because that shows the extra amount of effort anyone has put into the memorial and the extra amount of hard work that someone has taken the pain of doing. Therefore, these things do matter, and do not ignore these certain small matters. Any memorial will thirdly constitute a table of abbreviation, which is basically a table where on the left you write the abbreviations, on the right you write them in full, so that you do not repeat mentioning the whole word whole. Say for example, United Nations can be referred as UN throughout your memorial. Therefore, do not repeat the things you mention in abbreviation table is sufficing enough. Therefore, never ever repeat them once you are using them in the drafts, and therefore, by doing that, you are also trying to save your word limit and curtail it to the extent possible and have as many as issues as you can, because it makes a lot of difference. Even addition of one single word maybe 50 times means 50 additional words. You would like to curtail that 50 words for sure and make maybe another short submission. And therefore, yes, be very, very thorough with these kind of practices. These are small, aspects which will lead to bigger results. So, yes, as I again pointed out, I will repeat this, never ever forget these small kind of techniques. Next, what is very, very important is your table of authorities. Now, what is this? Is basically this should contain the list of all cases that you have referred, any other document, any other government policy, any other framework of law which will ultimately have force of law should be clearly mentioned in the list of authorities in a proper chronological manner. For example, it should start with the cases of Supreme Court, considering its national moot so far as Indian laws are concerned. It should start from the Supreme Court judgments, followed by a list of judgments of the High Court in alphabetical order, followed by maybe the name of the books that you have actually read and quoted. I will repeat this, never ever cite the books you have not actually read. So, next, you can have various journals, various research papers that you have actually read, which do have some authentic sources of law and may be considered well by the judges if you refer them. So be very, very careful in understanding what all things will qualify as sources of law, what all things will qualify as authentic enough to be cited in a memorial, and accordingly, please go ahead with mentioning them in your list of authorities. That means it should also be placed in your main arguments advanced. One good advice I can give about list of authorities is to make it more authentic. Please also give the page number at which it is cited and the para number that you are referring in the document. For example, your list of authorities, if you are citing the case of, say, Kesavananda Bharati, then what you should do is there should be one another column where your page number of where you have cited this in a memorial, maybe a 38 page, you have cited this case. That means your index should also contain that yes, it's cited at page 38, followed by another para where you will mention the para number of the judgment which you want to refer. That will just give more clarity, more, it will be, in a way, it will be more credit worthy so far as your mentioning about a particular authority is concerned. This just shows that you are so confident of citing even the para number. That means you have actually read and the judge will not prima facie doubt your citation. That's a good way of buying the judge just this impression in a way, so far as you referring certain things in the memorial is concerned. Next thing I would like to focus here is all sources of online resources like SSC Online, Manupatra, Hen Online, JSTOR, etc. should be categorically mentioned. That will just show that what all online resources you have used for your research purposes, just to add more creditworthiness and trustworthiness to your research. That's all about your list of authorities. That is ideally followed by your statement of jurisdiction. Now, in the statement of jurisdiction, going back the example I gave, you should focus extremely on the provision of law. That means you need to clearly mention that the petitioner is hereby invoking the jurisdiction of the Honorable Supreme Court under Article 32 of the Constitution. If there is any other provision applicable to your facts, please do give that. And next, what you need to do is just extract the whole provision you just mentioned. So if it's Article 32, extract Article 32 in entirety in your statement of jurisdiction and leave it there. That is a same simple statement of jurisdiction, and that's all you need to do in there. You should not establish your jurisdiction, you should not explain your jurisdiction, etc. in the statement of jurisdiction. Just leave it there, mention the provision you are invoking, followed by the extract of the provisions, and that's all enough for the statement of jurisdiction. This is ideally followed by the statement of facts. Now, going by my experience of mooting and these days judging, We prefer, having very concise statement of facts, to the point, just a narration. There should be a good interlinking between each sentence, each para, and max 1.5 page, not more than that. Ideally, I used to go for max 1 page. I never exceeded my memorial unless so required by more than 1 page. So far as statement of facts are concerned. Therefore, please, restrict it to 1 page if possible. If not, max 1.5 pages. Your rules will ideally cap it at 2 pages. So yes, obviously not beyond 2 pages under any circumstance for sure. Therefore, there's no straitjacket formula regarding the statement of facts. Just be as thorough. Mention the undisputed facts to the extent possible. Avoid mentioning the disputed facts. Obviously, if it's not, interlinked with the cause of action, then you need not mention them. So, yes, your statement of fact should narrate the whole sequence of events, the cause of action, the reason why you are before the court, how exactly there was a dispute between two parties, that means the source of the dispute, and brief background if required, if so required, because there are lots of propositions giving a lot of random facts which are not relevant for the dispute. You need to churn them out from your statement of facts and mention those statements of facts only which are required and only which are completely interlinked with your adjudication of the dispute is concerned. Therefore, yes, be very, very careful, therefore, while making your statement of facts and adhere them to the standard rules as given in the rule book. Next is statement of issues. Now, statement of issues is basically you need to derive from the disputed facts. Now, obviously, disputed facts are going to be argued and going to be argued at length, right? Therefore, it's very evident that only the issues will be framed from the disputed facts in the proposition. Therefore, understand the disputed facts and make a give them under a head, make them fall under a particular head. There'll be five heads is what you will get ultimately, and you make those five heads as the issues. It's as simple as that. So your disputed facts are the foundation for your issues. So build upon your disputed facts and frame your issues in such a way that there will be an ease of questions of law and question of facts, a mix of both if so required, only substantial question of law if the court that you're approaching requires it to be such. For example, in Supreme Court under a special leave petition, you can never raise any question of facts because Supreme Court is not a question of fact. Therefore, you'll have to restrict yourself, your so far as the issues are concerned, to the statement of or rather questions of law and not question of facts. So yes, please be very careful. Therefore, even while framing your issues, framing the questions, whether it's a question of fact, understanding whether what will constitute a question of law and what will constitute a question of fact is therefore also equally important. So that's all about your framing of issues. Now, the next thing is the simplest of all, but more essential, is summary of arguments. Now, summary of arguments is like pressy writing. What you need to be very careful about is not copy pasting your arguments advanced into your summary of arguments. Now, summary of arguments is actually a skeletal argument kind of a thing where you need to mention the main arguments, main ingredients of each and every argument, main substantive piece of law or some facts which will basically lead you to establish or substantiate some arguments. So it's basically a skeletal work, it's a model for your arguments. So be very, very careful therefore while giving these kind of preparing the summary of arguments. And as I already mentioned, never ever repeat and copy paste, especially from your statement of arguments as in the arguments advanced, because that's very, very it's always taken as if you are trying to avoid one part of your memorial, and just copy pasting doesn't work. Therefore, please be innovative in terms of your summary of arguments. Be extremely, diligent while framing the arguments, and therefore your summary of arguments have to be very, very carefully drafted. Next is your arguments advanced. Now, in arguments advanced, you need to follow one simple logic. That's IRAC. It's called IRAC. Now, I stands for issue framing, R stands for the rule applicable, A stands for assessment of the law and the assessment of the facts, or say analysis in itself, and C is conclusion. Now, what happens in this is I'll give an example to explain all of this. Now, consider that I'll going back to the same example of Article 32 petition. What happens is the issue is whether the petition under Article 32 is maintainable before the court. So your issue will have various sub issues, subsets of that. That's different matter. I'll come to that later. But primarily, your issue is the maintainability. Your rule over there is obviously Article 32. That's the applicable provision of law for your issue in hand. Next is any judgments will also qualify under the issue itself. Sorry, under the rule itself, where you need to cite certain judgments of the Supreme Court or even the High Court or any other forum so far as your applicability of facts are concerned. You need to fit in all these kind of rules into your second leg of submissions in a memorial. The third is the analysis, which is basically nothing but fitting in your facts to the applicable law that you just cited. You'll have to demonstrate as to how the facts are placed in such a way that they squarely apply to the law that you have already cited and quoted. And lastly, you'll have to conclude. By conclude, I do not mean that it's a one sentence thing of merely saying that yes, in the view of a forensic, we hereby submit that the petition is maintainable. But in fact, you need to summarize your whole argument in maybe one or two sentences so that you give a good recap of what you have argued in the preceding paragraphs. So any ideal memorial will have to follow the IRAC, as a systematic strategy, if not nothing else. The thing is, it gives you a good structure, and that's why it's very important. Next thing is, while framing of arguments, you need to be also, keep this in mind that you should have a lot of issues, lot of sub issues, lot of further subsets of each sub issues. I'll give you an example for this. If the issue is whether or not the petition is maintainable, then obviously the first issue is that the petition is maintainable under Article 32. The second issue can be here, as in the sub issue of the overall issue, is that there is a violation of fundamental rights of the petitioner. The other sub issue can be that the petitioner has a locus standi before the bench, and or rather the court. Locus standi for novices. Locus standi basically means the right of a party to approach a court in a particular matter. Next, you can also argue as a sub issue that the violation of the fundamental rights have been carried out by the state in terms of Article 12. And lastly, you can have another sub issue that the Supreme Court under Article 32 has the power of issuing directory reliefs. This will basically cover what you are trying to argue overall in your speech, because this is all the points you need to cover in your speech if you want to prove maintainability of any petition. That just shows that the ingredient of your speech can be divided into sub issues, and that sub issue should therefore be clearly highlighted in the memorial as headings, where each heading will give just one thought. So, the idea behind this is one thought, one sentence, one thought, one para, one thought, one broad heading. This should be the guiding mantra for your any memorial, because more than one thought will make things clumsier, and even having more than one thoughts in one para means your thought process has been diluted, but having them separately will clearly distinguish that okay, these are the basic points that the team has tried to cover, and that's how you also distinguish each point from the other by changing the para, by changing the sentence, by also changing the heading. Therefore, that's the basic strategy you should follow for any good memorial. Next is citations. Now, about citations, you need to be very, very careful as to how exactly you can go about certain things. Now, citations will give you a lot of aspects regarding, there are a lot of things like Blue Book citation, there is OSCOLA, and therefore it will give you a good exposure to various forms of citations and various rules followed by different individuals and different institutions. But make sure you rely on the citation which is given so far as the rules are concerned. So if your rules mention that you need to follow the ILI citation or you need to follow the Blue Book citation, please thoroughly adhere to that rule. Next, please be very, very careful while adhering and while checking the different forms of citations in different things. For example, for citing a case law, there might be two different versions of it depending on the scenario under which you are actually citing them. So, if there is any such thing, please first thoroughly go through the applicable rule and only then start, changing it to the format of the citation. Lastly, footnoting, be very, very careful about footnoting aspects. Now, footnoting basically means giving a reference of a source of law that you are trying to rely upon, or something that you want your, viewer to actually see once to prove the creditworthiness of your citations. So yes, if you are writing a particular statement, your footnotes should be given after each and every statement if possible. Ideally, my memorial used to run into more than 200 footnotes if it was a 25-page arguments advanced. So yes, footnotes, but never bluff in your footnotes. That's also equally important, where you should just rely on those cases which you have actually read. If you have not read a judgment, if you have not read a particular research paper, please do not quote them. I, as a judge, will definitely pick it up on a random basis and ask the students as to please tell me what is given in the particular case. So, if the student is not able to describe me the facts of the case or tell me the ratio of the judgment, then I will understand that he has tried to mislead the bench by citing a case which he has not even read. Therefore, yes, please be completely, careful about these kind of aspects in your memorials. Lastly, about memorial, it's the last important aspect is the prayer. Now, in the prayer, what you need to be careful about is just restrict yourself to what the court can give you actually as a relief, so far as the law is concerned. So, if the court can has the power of giving you a maximum compensation of say 50,000 as per the applicable statute, you obviously need to be careful about such key consideration, and you should not ask anything beyond 50,000 in your prayer. So if you have not read the law properly and if you have asked 1 lakh as compensation, especially where the court's limitation is to give you a compensation of max 50,000, in that case, I will see this as a huge lapse in your research. Therefore, yes, be thorough with the applicable provisions of law so far as what you're asking for as a matter of relief. Secondly, if it's also a situation that the court you are asking a relief for can is actually not entitled to give you that relief or is not empowered to give you the relief. For example, if you're asking a constitutional law relief like challenging a particular violations of regulation framed by the say the Central Commission of Electricity before the appellate tribunal for electricity because it merely has supervisory jurisdiction. But you have failed to understand there that such powers do not exist with the appellate tribunal because they can only adjudicate upon the orders passed by the commission and not the regulations framed by the commission in the under the legislative functions. Those can be only challenged before the high court. Therefore, if you have approached the appellate tribunal in that situation, that's again your lapse of research. In fact, you should have approached to the high court, and therefore the relief will give you that clear picture of what is possible before a court, what your client wants, and whether the court can give you that relief as per your client's expectations. So these are the last few things that you should keep in mind while drafting any memorial, and that's how you can go about your prayer. If you are from the respondents, just ask for a dismissal of the petition or dismissal of the appeal instead of writing everything in the prayer. And even from the petitioner side of the party who goes first, make sure you restrain yourself only to put concise reliefs. Do not just repeat your issues in entirety. Just ask for what you want, and that will be more than enough. So that's all about the mooting memorial making. And you need to be therefore just keep these things in mind. These are very few basic aspects that I mentioned. This obviously does not cover a wide range of aspects because of, I think, paucity of time. But yes, please consider these small things maybe as a starter, or maybe even if you are an experienced mooter, if you are not yet doing these things, if you're not following these nitty gritties of memorial making, please start following them. I'm sure this will help you in the long run, and I hope that if you follow these techniques, your memorial will definitely be placed in the top three at least of any moot court you're participating. Okay, guys, so I think I will end the session here. In the next session, you can expect me to deal with a few aspects on oral advocacy, and stay tuned for it. I look forward towards the session. Thank you, everyone. Hope all of you are doing well again, and stay safe. Thank you.